morning. Please be seated. We are here for oral argument on Dominguez versus Dominguez. It's our case number CV-24-0102. A couple things before we get started. First off, Justice Mary Elena Cruz has recused herself in this matter. So today joining us is Judge Lacey Gard, who is on Division 2 of the Court of Appeals. Thank you for coming up for us and filling in, Judge Gard. Secondly, counsel, you may reserve whatever time you wish for oral argument, but you'll have oral argument. You get 20 minutes for oral argument. You may reserve whatever time you wish for rebuttal, but you have to keep your time yourself, and there's a clock at the podium for that purpose. And with that, please begin.
Thank you, Your Honor. Chris Combs for the plaintiff, Dominguez estate. The court has requested authority on issues number 1 and number 4. Issue number 1 is a forged deed void ab initio. The general rule going back to English common law is that a forged deed is void ab initio. It's a nullity and cannot convey title. The Court of Appeals, ipse dixit, made their own law and ignored the law of 20 jurisdictions to rule as in regard to the equitable.
Mr. Combs, though, are we going to, under your position, do we have to overrule then the line of cases that began with Sparks, which said that we don't look at extraneous matters like what might have happened outside the document as long as the four corners of the deed seems to be a deed? Do we have to overrule those cases?
Well, a forged deed is a nullity. That's the general rule.
So do we have to overrule those cases?
I'm sorry, which cases are we talking about?
Sparks. Let's start with Sparks.
Pardon me?
The Sparks case. What's the full name? Sparks versus Douglas and Sparks Realty Company.
Yeah, neither of those cases are opposite, Your Honor.
And why is that?
Neither of those cases involve a forged deed.
What does void upon its face mean? Is that a synonym with void ab initio, or does it mean something else? Does it look to the technical components of a deed?
Well, one of the requirements is it be authentic. There's no question that the deed in question was forged. Renee does not even contest the forgery. She argues the 5-year paid property taxes go away with the forgery because it occurred 17 years earlier.
Counsel, let me ask you a question about that, because this is a motion for summary judgment, so we're going to assume for purposes of reviewing the record that the deed was forged. But, and this is a distinction that I think Justice Lopez or the Vice Chief is asking about, that if we were to look at the face of the deed, everything appears there that a deed should have. Different than some of the cases that the Court of Appeals and the trial court relied on, and that there was a problem with something within the deed. Other than the fact that, based upon our assumption that the deed is forged, and so the grantee, Renee, should know it's not valid, what other indication is there in looking at the deed that it's not valid on its face?
Well, Your Honor, we concede the deed was valid on its face.
Okay.
That's not an argument, but the Court of Appeals had not pointed to one jurisdiction in the United States, English common law, which is basically our law, and English decisions, France, Iceland, anywhere, there's not one case they've cited that defeat the basic proposition a forged deed is a nullity.
Well, but what they did do, and in fairness to the Court of Appeals and in fairness to the trial court judge here, was they tried to look at what this court has said about deeds and color of title. And even in the Sparks case, it did discuss this within the context of 524. They discussed a whole lot of other stuff, too. So at least in terms of what the Chief Justice's question was, too, do we have to distinguish these cases? Do we have to overrule them? Or is there a place for us to talk about a forged deed in the context of 524 that would allow us to acknowledge the forged nature of it and address whether or not it was a valid recorded deed?
Well, 12524 is a clear statute that applies to the owner of a property. And in the 525 applies to adverse possession, criminal trespass, and et cetera, et cetera. And I think that if there's any reason for the footnote, it is because the fear was that there would be some confusion about whether a criminal trespasser or an adverse possession claim to the property could survive if there was not that specific exception. 524, however, deals with the true owner of the property, not a criminal trespasser or an adverse possessor.
Let me ask you, on 525, the statute uses those specific words, forged deed, but 524, which we're dealing with here, uses the word recorded deed. What do we make of that?
Well, I think because 525 deals with someone who just criminally trespasses and attempts to acquire possession, that the footnote was warranted that under no circumstances could a criminal trespasser or an adverse possessor acquire title and in reliance on a forged deed. I think that's a huge distinction. I haven't convinced you, have I?
Well, I'm listening carefully because the struggle here is in part because Sparks discusses color of title within the 524 context, but it would appear that color of title is something that's important for the other provisions within the same article dealing with, as you mentioned, adverse possession type cases. And cases subsequent to Sparks have seemed to struggle with trying to identify what's wrong with the deed and does it matter in other cases, like Quality Plastics, the Sparks case, even Nicholas v. Giles, dealing with tax deeds. It seems in those cases that we've said consistently, the difference between a void deed and a voidable deed. Okay, that's all well and good. But how does that then apply to the specific context in 524 where almost, other than paying taxes, somebody paid the taxes. The dispositive element then, as is before us, is, well, okay, what then is a recorded deed, as a valid deed, as between a grantee and a grantor, where we're to assume that the grantee forged the deed? So we're not even talking about the validity of the deed as it pertains to third parties or bona fide purchasers or anything else. That's kind of where my struggle is here.
Well, like Quality Plastics is not a forged deed case. It involves a typo between 105 square feet and 150 square feet.
Right. And so, I mean, in Quality Plastics and those others, we're talking about there's some kind of a defect in the deed. Not forgery, but some kind of defect. And does that defect then render the deed voidable, or is it still color of title to satisfy the purposes of the statute? That's where I see the rub. So help me figure out, how do we acknowledge the unique circumstances here and distinguish what otherwise would be considered a deed valid on its face and recordable to reach the conclusion you want us to reach?
Well, yeah, we need to go back to the beginning. A forged deed is a nullity. Like I said, there's not one jurisdiction, corpus juris secundum, even going back to old authority, nobody uses CGS anymore. But going back to the old authority, current authority, Renee has not shown one case where a forged deed was anything other than a nullity.
Okay. And so then it gets back to our case law. that the Court of Appeals and the trial court, have we ever said that?
I'm sorry?
Has this court ever said that? That a forged deed is a nullity?
No, this court has not.
So how do we get there?
Well, the only authority in Arizona, and I'll probably get sanctioned, is a 2011 minute entry order from Judge Miles saying a forged deed is void ab initio. Why is there, in 120 years or whatever of Arizona jurisprudence, why has this issue never arose before? And the reason is it hasn't arose anywhere before. We could not find one case. Renee has not found one case where a forged deed was given effect. And not to make light of the situation, but you all know the LifeLock commercials, like, we will protect the title to your home, blah, blah, blah. If this court sustains the lower court, there will be a footnote, except in Arizona. Because right now, if this court does not overturn the Court of Appeals decision, this court will sanction a forged deed after paying property taxes for 5 years.
But would we, or,
No, I kind of see this a little bit differently, at least as set up by Sparks and as what the distinction that I see. And I wonder if you could tell me, what's wrong with this distinction. Because I agree with you. It seems to me that a forged deed is void as to make a conveyance. So if I gave you a forged deed to my house, and my husband said, "Oh, you can't do that. That's not my signature. Indeed, it's a forgery." It doesn't work. It can't convey title. But looking at 12.524, even though it doesn't say the words adverse possession and the next statute does, and the way Sparks described it is, in essence, it's set up for adverse possession, so that it doesn't allow for a conveyance. It establishes instead an adverse possession if you have a recorded deed that on its face seems to be valid, if the person claims ownership, which in my view, and Sparks had mentioned it, has to be the open, notorious, hostile type of ownership or efforts, and then you pay taxes for 5 years. So if all of those things are satisfied, then that person wins and gets the title. So it's not inconsistent with the idea that a forgery is a nullity to convey title. So tell me what's where I've gone wrong.
Well, as a real estate lawyer, and I think other real estate lawyers agree, there's a lot of bottom feeders in the valley. And if this decision stands, all someone needs to do is take care of an older person for 5 years, forge a deed, record the deed, take care of the person for 5 years, and pay the property taxes, and they own the property. That cannot be the legislative intent.
Well, it sounds inequitable to me, absolutely, but unfortunately, we have to follow the statute, and that's why I'm struggling with. I think we all are on Sparks and the language, but perhaps too, you want to move to the second issue, which is you do have a fail-safe here, which is when did this accrue? So your client finds out, hey, I didn't know about the forgery until X date. That's when this starts running. If we agree with you on that, what relief do you want? Because I didn't see that you asked for anything.
If you agree with us on that, what is the issue?
No, if we agree with the second issue that yes, there's a question of fact here about, or you didn't waive. I'm sorry. If we agree that you did not waive the equitable tolling and the discovery issue, what relief are you asking for?
Well, either under the second issue or the first issue, we get the relief we want.
Which is?
Should we send this back to the Court of Appeals, which hasn't addressed those issues on the merits, or address it directly of what the trial court did?
Well, I think this court can rule as a matter of law and doesn't need to go back on remand to the Court of Appeals.
Okay.
You're still not convinced. Nobody's convinced.
No,
we are sitting here dispassionately listening to the arguments of both parties.
That's right.
And will later render an opinion in due course.
I have a question about 12-525. We discussed it at length a couple of minutes ago, and there's two ways to look at it. And the first is Renee argues that there is this express fraud or forgery exemption in 525, the adverse possession statute. It's absent in 524. Therefore, forgery would not invalidate a recorded deed under 524. But I think there's another way to look at it. It seems to me that in the context of adverse possession, the claim against the true title owner is open and notorious. That person is put on notice by virtue of the physical possession. And 525B seems to me, I think you could argue, that it sets forth such a strong policy against the presumption of obtaining title through a forged deed that in this context, even though you have open and notorious occupation of land, that the adverse possessor will be deprived of those benefits merely by recording a forged deed. And it's maybe not obvious in this context that a forged deed would override the benefits of the adverse possession statute, but the legislature has clearly made that case. It seems to me that the policy statement against obtaining title through a forged deed is so strong in this context that it can be read into, in peri materia, into 524. What do you think about that interpretation of the statutes?
I think it's implicit in all the other statutes, and the distinction with 525 is the person acquiring title or who wants to acquire title unlawfully entered the property either as a criminal trespasser or claiming adverse possession. In our case, Magdalena, from 1995 until the forged deed was recorded in 2003, 8 years owned the property. Her daughter took over, managed her affairs, and probably, and this is no evidence because Magdalena passed away, but probably the property taxes were paid from her own funds that Renee, as a daughter-in-law, managed for her.
Yeah, and as applied in this case or similar circumstances, if you read 524 and 525 together, the legislature said in 525, even if you openly and notoriously occupy someone else's property, if you also recorded a forged deed, absent the adverse possession statute, your only claim to the property would be the forged deed, then you are deprived of the benefits of adverse possession. But then if you read into 524 that someone can obtain title with a forged deed, then the lesson is the way to obtain title through a forged deed is not to openly occupy someone's property, but just to go down to the recorder's office and file a forged deed and sit back and wait, and then you're entitled to the property. That seems highly inconsistent as a matter of public policy to read these statutes together that way.
Well, I agree with you on that issue, but the exigency of the adverse possessor is different than someone who already has had title for 8 years and relied on her daughter-in-law to take care of her finances, pay the property taxes. Only when Jose was murdered and Renee, her daughter-in-law, was a suspect in that murder, did Magdalena, in her early 80s, and her family look at paperwork and realize what had occurred. I mean, if this court sustains the Court of Appeals, it's a recipe for financial disaster for older relatives and younger children taking advantage. All they had to do is forge a deed, record it, and 5 years later, after paying their property taxes, come to this court and say, stamp my validity of ownership.
Mr. Combs, the Court of Appeals held that the estate did not raise equitable tolling in the trial court. You disagree with that. Why and how did the Court of Appeals err on that issue?
I'm sorry, on the trial court?
How did the Court of Appeals err in holding that the estate did not raise equitable tolling in the trial court?
Did not raise what?
the equitable tolling issue, which is issue 2 in this case?
Oh, well, now we're talking issue number 2. I'm sorry. Well, I don't think we raised it in the trial court, Your Honor, but we did raise it, and we cited the provisions of the trial court in the Court of Appeals on those specific issues of equitable estoppel, and cited the sections that it applied.
You want to reserve the rest of your time for rebuttal? You have 21 seconds.
Okay, thank you.
Thank you. All right, Mr. Broberg. And perhaps you want to start, after you get a chance to say your name, with answering Justice Lopez's question about the distinction he raised in reading the exception in 525 into 524.
I've got it right there, so I look forward to it. Good morning. My name is Lance Broberg with the law firm Tiffany & Bosco. I represent the appellee Renee K. Dominguez. I'm going to make 2 comments before I get to the Chief Justice's suggestion, which is probably my first failure this morning. Comment number 1, I would be loath to not deny the forgery allegation, which I know is not before your honors, but for the sake of my client, she's constantly been accused of committing a forgery, and she denies that. 2, the trial court asked me, and this leads towards your question, Vice Chief. The trial court asked me during the oral argument on the motion for summary judgment, Mr. Broberg, when was the last time you checked the title to your property? And I said, well, gosh, right after I learned about this statute is the answer to that, Your Honor. And the conversation then went the way I think all of us could see that, which is, does this statute create an opportunity for a ne'er-do-well? The reality is, we can all see where somebody who's unscrupulous could take advantage of this particular statute. We can see how to fix that. But it is ultimately not this body's job to fix that. It is for those down the street with the legislature. So going directly to your question in the comparison of 12.524 and 12.525. 525 is great because it provides that whole separate subsection in subsection B that provides an explicit exception in the instances of forgery. And so if this court were to apply a similar exception to 524, we're effectively saying instead of 4 elements, there's a 5th element, and the legislature just didn't include it, but we're going to include it for the legislature, which I believe, and the Sparks Court confirms, is beyond what this court is really authorized to do. I would also ask, look at 523. This is an interesting circumstance where the statute at issue, this 524, is sandwiched between 2 other statutes where the legislature did exactly what we've been talking about. Because in 525, the language is very clear in a whole separate subsection. In 523, which also deals with an adverse possession situation, it says that this does not extend to or include the want of, or includes language that talk about the want of intrinsic fairness and honesty. And so both the statute before and the statute after give an exception or a carve-out in instances where there's no good faith.
Is 524 an adverse possession statute as well?
It's not an adverse possession because you're really not talking about open, obvious, and continuous possession. It is a color of title as opposed to title, and that's a discussion we'll get into. It's a color of title statute whereby you record a document, it's within a lot or a city, it's recorded, you claim possession, and then you pay the property taxes for 5 years.
I know there's not a lot of attention paid to that in the briefing here, in the situation here, but in terms of Sparks at least talked about claiming ownership, and they certainly use language that smacks of adverse possession. In fact, they said adverse possession. They said this is an adverse possession situation under the iteration then of 524, and said claiming ownership seemed to be okay, you're in an open, notorious manner, you're occupying the property. So why isn't that? Would we have to take back Sparks?
No, I do not think we take back Sparks. In fact, when I originally started down this path, I really thought quality plastics was the case to follow. But the more you look at it, the Sparks case is the case that tracks this case the best. So first, the Sparks court, this court, said we're going to assume that the actual conveyance deed was void. And I want to focus on that void concept. Because the concept of whether it's void because of a forgery, whether it's void because of a lack of a notary, whether it's void because it was an improper treasurer's deed for some other reason, the only import is whether or not the deed is void. And then we get to a discussion about, all right, what is it? Is it a color of title versus does it actually convey title? By definition, if it actually conveyed title, there's no reason for a 524. There's no reason for a dispute because title was conveyed. And what the Sparks Court does is it takes you down the path that says, all right, what happens here is there's a color of title. It purports to transfer title. That title doesn't actually transfer until the 5 years and the elements of the statute are actually passed. And one of the things that's interesting, at least I thought in Sparks, is I learned a word. Because the Sparks Court talks about if all the elements are established, the decisor, and I think I'm pronouncing that correctly, but the decisor has an indefeasible title that can only be divested by the subsequent conveyance or a subsequent divisor. So what is a divisor? It's somebody who is wrongfully in possession of property or land. So the Sparks Court is specifically saying the person who is now claiming ownership is wrongfully in possession, and they start from that presumption. And what the Sparks Court does is it then says, all right, no title was conveyed. When that deed was recorded, nothing was conveyed. You're wrongfully in possession. But after 5 years, the statute of limitations has run, and title has now conveyed. That's why 527 is the one that says if a quiet title action is then brought thereafter, title is quieted in favor of, as the Sparks Court would say, the decisor. And this is consistently applied throughout Arizona from before statehood and into territorial days when it was, I think it was 702 of the revised statutes, all the way through. And I say that because I think Justice Montgomery brought up some of the other cases like Quality Plastics and the Nichols case. But it's interesting because this court has addressed the issues several times in the 60s. I think it was the Court of Appeals in the 70s. I think you came back in the 80s to address it. But in the Nichols case, just like in Sparks, they assumed it was a void or invalid deed to start because it's not important.
Before we get too far away from Sparks, counsel,
Yep.
because as I read through it, though, and I get down to page 127 of it, and the court discusses, and so I'm going to quote it so I don't mess up the point I want to make or ask you about. The fact that a person's name appears upon a deed as having been signed by power of attorney, whether in truth it was signed with or without authority, and though no acknowledgement was made by or for such person, this would not make the deed void upon its face as to those parties who did properly execute it. At most, it would be void and not binding as to the party who did not execute it. Additionally, we're not talking about a forgery in Sparks either, and I think you would agree that we're not talking about a forged deed in those other cases too. So with that as context then, can we take from the Sparks case then that where we have an allegation of a forgery as between the grantee and the grantor, that we're dealing with something different?
No, the concept in Sparks is just that, and it's true in all recordable documents. So if I were to sell a property to somebody else, we know what the deal is. If I don't record it, we still have an agreement, we still have a contract. But the rest of the world is not deemed to have knowledge of it. And if you look at Sparks, go to, I think it's on page 287 of that decision, but the court goes on to say, the appellee is not claiming here that the deeds operated to effect a conveyance of the city lots, but that such deeds operated to show color of title as one of the elements necessary to show ownership of the property by adverse possession under the statute. And so again, whether there's a forgery, whether there's a lack of a notary, whether there's something else wrong, the concept is just whether or not the deed, when executed and recorded, was it void, was it not void? And that's the consistent theme that runs from Sparks. It goes into the Nichols case, which I think it was a superintendent of streets deed, which I didn't even know existed. And then there's a treasurer's deed in Quality Plastics. In all of those instances, the underlying immediate conveyance deed was not an actual conveyance, it was void. But what happened is, after the 5 years, because the four corners of the document, and this is something Your Honor said, you don't have to look at extraneous materials. If you look at the four corners, it purports to be a transfer from grantor to grantee. It identifies the property, it includes language about consideration, and it includes the apt language about a conveyance of the property from A to B. So they have all of those things, so it purported to convey. It didn't actually do it, it purported to. That's the color of title. It's not until the 5 years pass under 524 that title is actually conveyed. So again, the concept that we're focusing on, whether it's a forgery or not, any other way that the deed is invalid, the courts have consistently, for more than 100 years, and this court specifically, said, it was void, I get it, but the time to challenge it has passed. And that's what that 5-year statute says. And again, I would invite, as our Vice Chief Justice suggested, if you look at 523 and if you look at 525, those both include exceptions. And the Sparks Court actually did a great job. The Sparks Court went through 5 other jurisdictions to kind of see how things would shake out in those other courts. And when it did so, it walked through, I think it was Illinois, Georgia, I'll be specific about it, Colorado. So the Colorado sister statute includes that the color of title must be in good faith. In Georgia, possession must not have originated in fraud. In Illinois, good faith as well as color of title are required.
What about Texas, which is where this statute apparently originated?
So Texas has, there's a couple of cases that are cited throughout, but they don't really deal with the application in a consistent manner. And so really what I'm doing is just, Mr. Combs is correct. When you look around the country, you don't see a whole lot on this particular kind of an issue. And what you do is you find other states that include good faith language or some other carve-out, like you see in 525 or 523. When you look through the rest of them, they include that good faith language. We don't have it. And again, if you look at the authority, even if you're not looking at the statute of limitations, the elements of 524, while explicit and express in the actual statute, have been defined pretty consistently. And when I say pretty consistently, I mean they're the same. Lot in a city or town, recorded deed. All of the case authority on that talks about whether or not it's void on its face. And so we're talking about color of title and whether it purports, not whether it actually conveyed, but whether it's color of title and whether it purports to transfer property.
But it's on that point, and I mentioned it to your opposing counsel, where I struggle in that, and again, we're dealing here with a circumstance we haven't seen on those other cases where it's as between the grantee and grantor. The grantee, again, I appreciate the fact that your client's denying that it's forged, and we're assuming it as part of a motion for summary judgment. But if the grantee knows that the grantor's signature is forged, then at least as to the grantee knows the deed is invalid on its face.
Right.
Why can't we make that distinction here?
Well, there's a couple of things there. So if the grantee knows that the signature is invalid, the grantee is not the one attempting to enforce a right or a claim to the title. It would really be the grantor, because the grantor is saying.
But to that point then, and Justice Bullock alluded to the fact that we got this statute from Texas, and I'll give you this site.
Sure.
It's McDonald v. De Los Fuentes, 26 Southwest 792. And it's a Texas civil appellate case from 1894, so it goes back a ways. Holding that a statute of limitations defense is unavailable if any link in the chain connecting defendants with the sovereignty of the soil was forged, because they would neither have title nor color of title. And I wonder whether or not that is a fair distinction to be made in this particular context, again, where we're only talking about the grantee and the grantor.
Well, but the question still is, what is color of title? And I think Arizona doesn't need to look anywhere else, because our case authority has defined what color of title is. We've done that year over year, decade after decade, for over a century. And the color of title really focuses on what our Chief Justice focused on, which is, if you look at the four corners, does it purport to convey title? Does it include all of the indicia combined together to suggest and purport that this actually conveys title? If it does, that's it. You don't look at extraneous information. The extraneous information is and so on all of these. Forgery requires the review of extraneous information. And again, the idea of a forgery here, it's distasteful. It's the F word here. It is a concept that makes us say, this feels like an opportunity for a bad actor. But it's a red herring, because any reason that the underlying purported conveyance deed is invalid simply makes it a void transaction. That was the case in Nichols. That was the case in Quality Plastics. That was assumed in Sparks. And so we can assume, for purposes of today, all three of those are void, and we can assume, for purposes of today, that the 2003 recorded deed, really signed in 2002 and recorded in 2003, we can assume it's void. I don't think it is. We can assume it's void. And if we assume it's void, we don't have to go into why it's void when you look at this statute. And the reason we don't have to is because there's no subsection B like in 525. There's no subsection B like in 523. And that's what this court has consistently said throughout. Again, I would say if you look at that court, And what we said in Sparks, it says everything that we already know, which is we have to assume that the legislature knows what it was doing. We have to assume, and the court should not question the wisdom of the legislature, but at the end of the day, if we have to add some language to create an exception in the instance of fraud, or who knows what other things could happen, a void treasurer's deed, a void superintendent's deed, or superintendent of streets deed. If we have to add that language, we are adding to a statute that is otherwise clear on its face.
Can you give us a little bit about the interplay between 524 and 525? As I read them here, and here we didn't take the issue of the city or town, so assuming that this lot's in a city or town, it seems like both would apply because it's real property, as said in an action to recover real property, and it's also, falls under, as we know, 524. So I was having a little bit of trouble trying to distinguish between the two. If they both apply and simply 525 does not because of the allegation of forgery, so 524 applies, it seems like that gives some sway to what Vice Chief Justice Lopez was asking about. Shouldn't they be read in pari materia and kind of importing that concept into 524?
Your Honor will love 523. Because it's
and
also,
520.
it's also very similar, but gives a 3-year statute. The reality is, when 523 and 525, we're really talking about an adverse possession. And we're familiar, I think there was a Guzarowski case that came from this court about the open, obvious, notorious, and then there's a presumption of a hostile use. This doesn't require any of that. 524 doesn't require any of that analysis. It doesn't have to be an assumption that it's hostile. It doesn't have to be an assumption that it was open, obvious, notorious. It doesn't have to have any of those other indicia of an adverse possession. All that has to happen here is that there's a purported transfer. So, for example, if I were to engage in a transfer to another party and we simply messed up, but that party takes title and has possession, I transferred more than I thought, there's some kind of an error. Everybody agrees there was an error. After a certain period of time, under 524, it now becomes barred, and I'm unable to bring a quiet title claim in order to
I'm not
transfer.
so sure about that, because it seems to me that you're skipping over some language in 424 that Sparks actually mentioned. As I've said before in other questions, it says a claim of ownership.
Right.
And so there's no reason to put a claim of ownership in there if the deed itself is sufficient. It seems like a third thing, a deed, claim of ownership, and taxes. So claim of ownership must be something, because we don't think it's superfluous. So it must be something. Sparks said it's showing more of that open, notorious, ownership. You're on the lot, you're growing crops, you're building a house, whatever, to kind of demonstrate that. So I have kind of trouble going back, keep circling back to, isn't this really an adverse possession? Which is what Sparks said it was.
Let me change it this way. So traditional adverse possession it doesn't involve normally some kind of a conveyance deed. It's I built my house over the property line. I accidentally put a road across your property because I didn't do a survey beforehand. That's your traditional notion of an adverse possession. Can we call this an adverse possession? We absolutely can, because you're taking title to a property from a decisor, as a decisor wrongfully. And at some point, there's a statute that says once you've done that for long enough, it becomes your property.
Doesn't that make then 524 superfluous? It sounds like we're reading 524 exactly the way 525 sounds. And honestly, that's the problem I have with Sparks. By referencing adverse possession, it seemed like they were conflating 524 with 525.
523 references adverse possession as well. And so when you look at the three and you try and distinguish why is it a 3-year statute of limitation for 523 versus a 5-year set forth in 525, it's unclear.
Did 525 or something like it exist in the time Sparks was decided?
That is a great question. I want to say it did, but I cannot say that with certainty. And I say that just because this comes from the revised statutes 700 through 702, and that would be 3 statutes. And it strikes me as being coincidental that we're talking about 523, 24, and 25.
In the remaining time, issue 2.
Yeah.
It seems to me that the Court of Appeals, and these rules come from the Court of Appeals, is very draconian on this stuff. And on waiver, I should say, and when I look at it, I look to see whether the question was actually litigated or not. And it sure seems like these issues were litigated in the courts below. Why am I wrong about either the standard or applying the standard?
Two motions for summary judgment. The first one granted on 12-524. There was no equitable tolling argument raised in response to that. The argument that was raised is simply that there's never a statute of limitations applicable to a cloud on title claim. So a totally different type of an argument. And so there was no equitable tolling. So when that one was resolved, the first time an equitable tolling argument was raised on 524 was in a motion for reconsideration. And the case authority is pretty clear on that one, that you don't get to raise it for the first time in a motion for reconsideration unless there's some explanation or evidence that it would be manifestly unjust.
I want to press pause for a second.
There was an oral argument transcript, though, on August 20, 2021, where Ms. Fine is discussing equitable tolling in the context of ARS 12-524. Is that not sufficient?
I would then go to the next level. If you look at the court's ruling, the court doesn't get to that issue at all.
Why does that matter?
Yeah, that's the court not addressing it. It's not a party waiving it.
Well, from my perspective, and I have 3 seconds, I'm going to jump right to the answer on this one. So one, I do think it was waived because it was not in the briefing on this one. Two, I would point your honors to the actual argument in the briefing on this, because there was no evidence to support any of the argument. Just like what you got with the Court of Appeals, there is a single conclusory statement that simply says, and I will quote, there's 2 sentences. Magdalena did not know of the fraudulent conveyance of the Buckeye property until 2020. She's non-English speaking, senior citizen who only spoke Spanish, was entitled to rely on her daughter. No citations, no evidence. The record, however, showed the recorded deed in 2003, the probate and the 2-year requirement by statute to settle the affairs of the estate of Magdalena's then husband, who is also one of the purported grantors, and then the statutory 5 years. So if the notice provided under 12-524, that of paying the property taxes, is sufficient for that statute, why would it not be sufficient here? And so there's simply no support that has been provided at the trial court level or at the Court of Appeals to suggest that an equitable tolling somehow beats all of those arguments and somehow defeats the plain language of 524. I'm clearly over my time. I'm staring at zeros.
Great. Everybody all right? Thank you.
Thank you.
All right, Mr. Combs, please. Do you have any rebuttal? You have some time. I'll give you even a little bit more because Mr.
24 seconds.
I will give you at least a minute and a half. How about that? Go ahead, if you have anything.
Well, we've been dealing with each other for 5 years, so he's a very good lawyer, he's very bright, he's very articulate, but he can't change the facts. This will be, to our knowledge, and we have no opposition from opposing counsel, the only decision, at least in Anglo-American jurisprudence, enforces a forged deed to convey title to property, especially not to someone who was suspected of murdering her husband and who took advantage, without question, took advantage of her elderly mother-in-law by keeping her in the dark for 13 years or whatever it is until she and her members of her family finally figured out what was going on and came to see us. So that's more than a minute and a half, but thank you very much.
Thank you. I thank both counsel for your argument today and your briefing. We know this is an important matter. We'll take it under consideration and issue a decision in due course. And meanwhile, we'll stand adjourned for the day. Thank you.